All right, we are waiting for the stream to get cracking. Looks like we are on live now on Periscope, waiting for Facebook. Looks like YouTube is connecting. And I do believe we are live. Hi, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here in Scottsdale, Arizona. My office is the R&R Law Group. We do criminal defense law. We've represented thousands of good people facing criminal charges all across the state of Arizona. And the reason we started Watching the Watchers is because over the course of those years representing many, many people, we've seen a lot of malfeasance, a lot of problems in the criminal justice system. And we believe that there needs to be more discussion about how we can properly reform that system. And so Watching the Watchers was born to hold people accountable, specifically those involved in the justice system, police, prosecutors, judges, politicians, basically anybody who's involved with incarcerating people or arresting people, taking them into custody, processing them through the system. We want to hold them accountable. They're in a position of power. They have all of the cards. They control the entire system. And so when they do things that are bad, it really imbalances the scales of justice and it needs to be remedied. The only way we can do that is with you, with your attention, with your focus, with an active citizenry. We as a society can help institute some change. So that's why the show was born. Now, what are we going to be covering today? By the way, if you're not a subscriber on the channel, YouTube is our home base. That's where you want to be. That's where everybody is. That's where all the chat is going on. And that's where I'm going to be reading the comments. So head on over to YouTube. You can go to rrlaw.tv or watchingthewatchers.tv, and it will forward you right there to our YouTube page. Hit the subscribe button, and then we can be friends. So today I want to talk about, of course, there's a lot of news going on, but we're going to spend some time focused on Kyle Rittenhouse. He had an extradition hearing today, and we have some clips from that. We have some of the law from Illinois. We've got some sound bites from the judge and from his attorney, John Pierce. So we're going to be talking about that. We've got a couple of smaller updates, one about Breonna Taylor. A law professor from Rutgers actually came out and said that the attorney general in the Breonna Taylor case got the law wrong. We covered that a little bit yesterday, but it's always good to have confirmation from a law professor. So we've got some stories about that. Then we see a situation where a woman named Alecia Kitts was actually arrested at a sporting game. She was not wearing a mask, and another officer came up and actually removed her from the stadium, but not before tasering her, giving her a little bit of that electrical juice. So we've got that video. We're going to talk about that, what that means. Is she going to be charged, what her options are, and how that's going to work. And then, of course, we're going to wrap the show up with the SCOTUS nomination discussion. SCOTUS HQ, we've got a lot of sort of gossip about that as well. President Trump is expected, actually he's planning on announcing his candidate for the nomination to the vacancy in the Supreme Court tomorrow. I believe that's happening tomorrow afternoon, 5 o'clock Eastern, which means that'll be about 2 o'clock our time. And so we may cover that, we may not, but there are some news that we need to discuss in anticipation of a huge announcement, one that is going to really tip the scales of this court if the nominee is confirmed by the Senate. So let's get into the meat and potatoes. First story that we have is Kyle Rittenhouse. We want to free Kyle. We can see that a lot of people are very upset about this case. This channel's gotten a lot of commentary about it. One of our highest viewed videos is about Kyle Rittenhouse because I think it is so interesting. This is one of those cases that kind of comes across, I think, once in a lifetime, where you have somebody who's being charged with a crime when, in my mind, it's really, really difficult to justify the accusation, to justify the criminal charges against Kyle Rittenhouse. We've covered it ad nauseum on this channel. Some very, very detailed, in-depth videos on that. If you haven't seen those, go check those out. But now Kyle Rittenhouse, a little bit of sort of backstory. He is in custody. He is in custody in Illinois, and we're having a conversation about whether to extradite him back over to Kenosha, Wisconsin, which is where the underlying event happened. And so today he appeared virtually in court in Wisconsin, and this was part of the docket that we were able to see. Here is what it looks like. This is what we saw. So the actual court date was scheduled for today. Leading up to it, we saw that there were some defense motions, and then there was an order that the media could be present or be a part of the hearing today. And then we have a new court date that is actually scheduled for October 9th. So what happened today? Well, before we dive into what this all means, I want to explain sort of how extradition works in Illinois, because it's interesting. We're going to hear, I'm going to explain what the law is a little bit. Then we're going to clip over to to the actual court proceeding where we're going to see the judge, we're going to see John Pierce, his attorney, we're going to see the prosecutor, and we're even going to see Kyle because he was a part of this proceeding. So we're going to go there, but before we dive into it, it's going to make a little bit more sense if we understand what the extradition laws in Illinois say. And so let's take a look at the actual rules from the Uniform Criminal Extradition Act as it is being implemented in Illinois. Now, it's going to be, again, a wall of text. I'm underlining in red what's important. Then I will summarize it. So here, this comes from 725 ILCS 225. This is the Uniform Criminal Extradition Act in Illinois. This is in Chapter 60, Paragraph 19. And it says here, when you have a fugitive from justice, the governor has the duty to do something about it. So the governor of Illinois, it is the duty of the governor of this state to have arrested and delivered up to the executive authority of the other state any person who is charged with treason, felony, or other crimes or anything, and they fled from the state and they're found in Illinois. So that means that the governor of Illinois has to take some responsibility for this thing. He's the chief executive of that state. That means that when he gets a request from Wisconsin, it's going to go through his executive office, which is the prosecutor's office. Remember, the executive branch is the branch that goes and executes the laws that are passed by the Congress. The judges, the judiciary, is the body of government that actually decides whether those laws are constitutional or not. So in this case, one governor, the executive from Wisconsin, needs to communicate over to the governor of Illinois saying, hey, we have an interest in this individual. We want Kyle Rittenhouse back. He committed a crime in our state. Think of this like different countries. We've had this conversation on this channel before, but think about this as being China versus the United States. If China decided that they wanted me, if they said, hey, that Robert Gruler, he has been speaking some nonsense about China, we want him. I would hope that the U.S. government would say, hang on a minute, we want to investigate that. He's our citizen. He's hosting an amazing show on YouTube. We're not going to let you just take him into your custody. So that's what the conversation would be. I would want my government to protect me. The states, even though we're all part of the United States, we also have each state is its own sovereign entity in a lot of ways. And we have this concept of federalism where you got federal government and state governments. We have the full faith and credit clause, which is in our Constitution, which says that the states should be communicating with one another. If you get married in California, Arizona is going to honor that, and back and forth. So there's all these rules of reciprocity and so on and so forth. But when somebody is charged with a crime and one state is saying, we're going to punish that person, we're going to take away their liberty, we're going to prosecute them in our courts, we're going to put them in our prisons, we're going to, basically put them through our own version of justice as we handle it in our court system, then Illinois is going to come back and say, wait, we want to make sure that you're doing it right. And the governor's offices are going to be the bodies that are responsible for doing that, for actually processing this through their agencies. The extradition laws, if we go on, we're going to see that some things are required. So I want to talk about specifically what does Wisconsin need to do before Illinois is going to transfer Kyle Rittenhouse back over to Wisconsin. And so this is, again, a big, long paragraph, but I've sort of given you a brief summary, 5 bullet points on what you need to know. This comes from Section 3 from the same Extradition Act. And what you're going to see here is that no demand for extradition of any person is going to be recognized by the governor unless the accused was present in the demanding state. So what does that mean? That means that Kyle Rittenhouse was actually in Wisconsin. That element is met. That is something that is without dispute. He was there. There's video that he was there. And so they're demanding that he comes back. He was there at the time of the alleged crime. And then after that point in time, we saw Kyle actually left Wisconsin and went back to Illinois. So this second element, that thereafter he fled from the state, is also going to be met. Then we're going to see that there needs to be a copy of an indictment. So the governor from Wisconsin needs to actually indict him. That has already happened. We already know that there's a court case that's pending in Wisconsin. So there was an indictment. There's a bond of $2 million out of Wisconsin, and that case is moving forward full steam ahead. They're just waiting to get their hands on Kyle. So we know that there was a copy of an indictment, and as we go through the clips from today's video, you're going to see from today's hearing, you're going to see that they're actually talking about this. So the indictment gets kind of passed around a little bit, and Kyle's team does not have that. So those things are in process. Kyle's attorney is going to get a copy of all this stuff. He just doesn't have it yet. And all we're going to see down here that the indictment, the information, or the affidavit must also substantially charge the individual. So it needs to substantially charge Kyle Rittenhouse. I think that's going to be a term of art that we're going to get into a little bit as this progresses. And then they also need to, the governor has to authenticate everything, and the individual also has to be served with this documentation before it's going to be effective. So Kyle Rittenhouse specifically needs to be served with these documents before he can start to respond. He's on notice now. Hey, there's an indictment against me. Then he can file his writ of habeas corpus. So we're going to talk more about that. Now, I wanted to reintroduce you, if you have not already remembered who this was. This is John Pierce. He is sort of the front man in a lot of ways for Kyle Rittenhouse's defense team, him and L. Lynn Wood. And he is saying, reaffirming his defense, which was that Kyle Rittenhouse was a teenager. He acted in self-defense. He was a courageous defender of liberty. He's a patriot exercising his right to bear arms amid rioting, chaos, and turmoil in the streets. And so that is who was appearing today at the extradition hearing proceeding. And we actually have a video of a little bit of that proceeding. Now you can see here, this is the judge. This is attorney John Pierce. This is the prosecutor. This is Kyle Rittenhouse. So you see him sitting there. He was brought into court, and he is in a face mask. And he doesn't say anything in this clip at the very beginning of the hearing. He does say, good morning. That's it. We don't hear anything else from him. And these other people, this is looks like the probation officer, somebody else from the court, somebody else from the court. We've got another attorney, not sure who that is. Oftentimes we'll have, so I think John Pierce has another attorney who is helping him on this case because he's not licensed in Illinois. So he's got somebody who's doing pro hoc vici, or he's doing pro hoc vici, which means he gets to appear in court because he's being endorsed by another attorney who is licensed in that state. So we've got a number of people on this proceeding, got a court reporter, got somebody from the probation department. Because Kyle is 17, he may have a guardian ad litem who is an attorney who's going to be looking out for his interest as a minor. I don't know, but this is a little bit of the clip from the court proceeding this morning.
Anything to report with regards to the status of extradition hearing today?
Well, Your Honor, this is John Pierce. I mean, I can tell you just very succinctly, we intend to challenge extradition by writ of habeas corpus, and so we would ask that the procedures be put in place whereby extradition documents are in fact sent from Wisconsin so we can review them, and then we would ask Your Honor we'd like to handle this in an orderly process so that we have a chance to review those, have a chance to prepare our petition. Any other briefing, and then set a hearing date on the petition, Your Honor.
Your Honor.
Yeah, and then at that point, that prosecutor kind of chimes in, and she starts to say, well, we've already confirmed that we've got the warrant from the governors, and all of that stuff has been sent over to the sheriff's department, and the sheriff's department is in possession of it. And they go back to John Pierce, and he says, yeah, that's great, but we don't have it. And so this is a lot of the time, this is what you see in criminal court a lot of the time. It's not that interesting. If you think that criminal court is like what you see on Suits or on, Law and Order, or this is it a lot of the time. It's just, hashing out the specifics of who is doing what by when, who is getting the documents sent, where are they, has this exchange of information proceeded according to the law. And so that's basically what they're talking about now. They're saying, hey, these are the rules that we just went through, and we need a copy of that indictment, and it needs to be signed off by the governor, and we need a warrant, and we need all this stuff. So, where is it? And this judge is just sort of hashing out those details. All right, so get it over to him and all that stuff. Now, John Pierce has indicated that they are going to be certainly challenging the extradition order. They're going to be fighting that. They want to keep Kyle in Illinois. And the next question becomes, okay, well, the big issue here is Kyle's got to get out of custody. He's been in custody for a long time now, and these cases can take years. We've covered other cases where, $2 million bonds have been reduced down to $400,000 bonds. That was another case out of Kenosha. The issue is he's in custody. People want to get him out of custody. He wants to get out of custody. His attorneys want him to get out of custody. And that's what the initial part of a criminal case is all about. It's about setting release conditions and then putting a plan in place to continue representation as the case moves forward. But if if Kyle's in custody for 2 years, I got to tell you, that is an extremely long time. Even any amount of time in custody is a long time. 2 years for a 17-year-old young guy is insane. It's a long time. And so what happens from my experience is that people who are in custody for that length of time, they start to lose their willpower. They change as a person. They go in as a young 17-year-old man, and then he's in prison for 2 years. He's going to come out as a 19-year-old different person entirely. And you want to prevent that, right? We want to see what we can do to help him not have those same ramifications. It's not just Kyle, it's anybody who goes into custody. It is a traumatic thing. Life is different. And many people would say there's good reason for that. But in this situation, the highest priority at this point in time for Kyle and his defense team is to get him out of custody. But is that possible in Illinois? So let's say, for example, they don't actually extradite him, or they file this writ of habeas corpus or whatever, something happens. Can he get out in the meantime? Can Kyle get out of custody while all this stuff is pending? Because the next court date today was another continuance. We had John Pierce say he needed some time to actually file his petition for the writ of habeas corpus, and that is going to take he asked for 30 days. The judge gave him 2 weeks, so their next court date is on 10/9. So, every time there's a continuance, it's just more time Kyle's sitting in there, and it's less time that work is being done to get him out. Now 30 days I don't think is unreasonable. 2 weeks is also not unreasonable, but you want to see this stuff move quickly. But anyways, can he even get out in Illinois? So let's say that he stays in Illinois. What do the rules say about Illinois? Well, they're not particularly good. So this is what comes from Section 16. It says bail. Again, this is part of the uniform extradition hearing. Now, this is one of the worst statutes I've ever seen written. It's really bad. It's really hard to read. So let's read through it, and then I'll just give you the in other words down here at the bottom. It says, unless the offense with which the prisoner is charged is shown to be an offense punishable by death or life imprisonment under the laws of the state in which it was committed, a judge in this state may admit the person arrested to bail by bond with sufficient sureties, and so on. So in other words, what this is saying, bail is allowed unless the crime is punishable by life or by death in the other state. So, I don't know why they write these statutes these ways. It's old language. It's really, really confusing. This is a criticism of lawyers and lawyering that I 100% agree with. Don't know why this stuff can't be written in plain English, largely because it's just holdovers from decades and decades of lawyers thinking they're very smart, crafting these statutes. But all this is saying is if this crime in Wisconsin is punishable by life in prison or by death, then Illinois is going to honor that. They're going to say if it's ordinarily punishable in those other states by one of those two things, we're not going to issue a bail. We're not going to issue bond. So Kyle cannot get out while this is all pending. So he's got a $2 million bond in Wisconsin, but essentially right now when he's in this period of limbo, he's got no bond. He can't get out of custody at all, which is why now you start thinking about these things. Well, now John Pierce and Bainbridge and Ellen Wood, now they've got a strategy to file this writ for habeas corpus, but is that going to be successful? Are they going to be able to get him out of custody in Illinois? Would it be a better decision to just transfer him to say, hey, we're not going to fight extradition. Let's just go fight this thing in Wisconsin, so that, the judge set a bond there. And we know from prior precedent that I've covered on this show, the name of the case escapes me. I think her name was Crystal something, where she had a $2 million bond or a $1 million bond. They reduced that down to $400,000 in the same jurisdiction, similar murder charges. So she got out of custody, whereas Kyle Rittenhouse in his current situation is not going to be able to get out of custody. If he were held over if he were held under Wisconsin law, anyone who is 17 or older is treated as an adult in the criminal justice system. And when you're facing murder charges in Wisconsin, that's going to mean life imprisonment. So especially if he's convicted of the first-degree murder intentional homicide charge. So that would mean Illinois is going to honor those rules. They're not going to let him out of custody. We have another clip, but before I get there, I want to share with you the rights of the accused. So now let's say that Kyle Rittenhouse, he's in custody, right? And he's waiting for these documents to be transferred back and forth. And he's got, some information that he's looking to obtain from his attorneys and so on. So what can he do? He's in custody. He's waiting for all of this stuff. So what are his rights? We're We're going to talk about habeas corpus, but let's take a look at what the law says first in Illinois. So habeas corpus is such a huge topic. We're going to cover it briefly. I'm going to give you a little bit of information on it, but it's really important. It's a concept that's discussed in our Constitution, and it's a big deal. It's the right of the accused to challenge their incarcerations. It's to challenge their being in custody, and it's important. So let's talk about what the Illinois law says we can do as leading up to habeas corpus. So here is the statute from Illinois. This comes from Section 10. It says the rights of the accused person. Again, big wall of text, but I summarized it over here. It says the rights of the accused. No person arrested upon such warrant shall be delivered over to the executive unless blah, 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 unless they inform him of the demand made for his surrender. So that's the notice to the defendant. So they can't just go and just, pick him up and transport him back to Wisconsin. They have to show him what's being asked of him. It's being demanded that you surrender and also inform you that you have been charged with a crime. At that time, he has the right to demand and procure within a reasonable time and opportunity, not less than 24 hours, legal counsel. So once he has notice that this is happening, he has the right to go get an attorney. He has done that already. And if the prisoner or his counsel, they can test, they can challenge, they can fight the legality of his arrest. So the court will then fix a reasonable time to be allowed to apply for the relief by habeas corpus, and then they're going to move forward and they're going to set a hearing, and they're going to, the case is going to move forward. So those three things, right? Notice, Kyle got notice. He's going to get formal notice very soon because they were delivering the signed warrant and the indictment and all the information that's coming over from Wisconsin. They're going to get that over to Kyle, and then he's going to be officially on notice at that time. He's already got an attorney, and then he is going to challenge the situation by filing a writ of habeas corpus. His attorney is going to talk about that, and we have a clip of what they're going to be investigating here in a quick minute. Here is the legal definition of habeas corpus, and I've got an example I want to run through with you. A writ of habeas corpus is used to bring a prisoner or other detainee before the court to determine the person's imprisonment or detention is unlawful, whether it is allowed to keep that person in custody or not. Habeas petition proceeds as a civil action against the state. It's used for extradition processes, bail, and to challenge the jurisdiction of the court. So one of the best examples that I came up with to sort of explain how this works is this idea of the right to a speedy trial, right? Everybody knows that. You learned that in civics class or social studies when you were growing up. When you're in custody, one of our founding principles in our justice system is you have a right to a speedy trial, because we didn't want the government to put you in prison and just let you sit there and rot while they just were prosecuting you. We're continuing to investigate it. We see this a lot with the investigations of our government, right? We saw the Mueller investigation take 2 years. We're now seeing the Durham investigation take 2 years. So imagine if that were you, if you were in custody, say for a shoplifting charge, and they just said, well, we're just continuing to investigate. Yeah, I mean, we're going to continue. We got more people to talk to. There were a lot of people in that Target that day. You stole those pair of shoes. So we're just going to keep investigating this thing for years and years and years, and you're just going to sit there and rot. The writ of habeas corpus, this concept was discussed in our Constitution, and it explains that if you're in custody as a prisoner, you have a right to challenge that under certain conditions. It was discussed. The Congress sets the rules on these things. So it's a whole unique, different area and body of law. But if you're in court, you want a speedy trial, you say they're not giving me my speedy trial, I'm going to go sue them. My due process rights, part of my rights as a citizen, as somebody living here, is that I get a right to a speedy trial. You're not giving me that, therefore I'm going to sue you. That's what's happening in this case. So here, the big discussion is going to be about, is Illinois justified in keeping him? And part of what we're going to talk about, well, let me get to this next clip, and then we'll talk about maybe one of the arguments that Kyle's team has as to why Illinois should not actually keep him based on the evidence that they have in Wisconsin. But before we dive into that, let me show you this next clip, more information about the proceeding that took place this morning.
For the record.
Your Honor, just one housekeeping matter. To date, when we've had a chance to see Mr. Rittenhouse, we've not been permitted to take in any electronic devices. We would ask for an order that we be allowed to do that, simply because there is, as you probably know, an immense amount of video evidence, et cetera, and we really do need to be able to review that along with our client. So we would ask that we be able to do that.
So what specific electronic device are you talking about?
Like a laptop, Your Honor. We're not going to be recording anything. We just, we need to be able to show him evidence and to talk to him about it. That's all we're looking for.
Very well. State your position.
Just so I'm clear, they're asking to bring their own laptop into where Mr. Rittenhouse is being held.
So it doesn't necessarily have to be my laptop or our laptop. I mean, we're just looking to be able to have, a laptop so that we can review evidence with our client. To continue to investigate the facts and understand our basis for potential habeas petition.
I have no objection to that, Judge.
All right, very
Had to
well.
think about that
what
one.
I'm going to do is it's going to be subject to the detention rules. There's no recording. They have specific rules for those. At this time, I don't have a copy of that. I don't have a written motion for this request, counsel. So what I'm going to do is I'm going to table this motion. Absolutely having a right to just review items with your attorney, with your client. However, we need to make sure that what specific rules we're asking to modify or amend. So if you want to follow that up with a written motion, and we'll address that. If you want to set a shorter date with regards to that issue, if you want to address that with your client prior to the filing on October 9th.
Yeah, yes, Your Honor. So of course we'd like to, be able to have the chance to do that ahead of filing the petition. So I mean, we can file that today or tomorrow. It should be pretty straightforward.
Absolutely, but specifically which rules you want to amend, I would need to understand which rules you want to amend.
Understood, Your Honor. We'll make that clear.
Very well. And so if there's not an agreed order between the parties, counsel, you can motion the case up. If there's an agreed order, I'd be happy to sign that and allow access pending the agreed order between the parties.
Yes, Your Honor. Yes, Your Honor.
All right, very well. Anything else for the?
All right, so it sounds like Kyle's going to be able to get, some sort of technology at least in there with him so that John Pierce and his legal team can review some of the evidence and discuss what is pending against him. Now that, again, this is not that interesting stuff. This is more minutia, right? We need to bring a laptop in there. He needs to review some of the evidence. Prosecutor has to think about it. Well, what's going on with the laptop? What are you going to be doing with that thing? Is he going to be communicating with anybody? Is it your laptop? Is it our laptop? Is he going to be tweeting from there? Are you going to make a video? Are you going to record it? This is what goes on. I mean, this is the conversations that we have. And, it's interesting a little bit. You can see some of John Pierce's style sort of evolving in this case. You can see it sounds like a lot of this stuff is being hashed out orally right here on the record in court. That's one way to do it. I'm not saying it's the right way or the wrong way. You can wait until these court proceedings take place before you start hashing these issues out. Or as the judge was discussing right there, there was no formal written motion submitted, which is what the judge was looking for, right? The judge says, well, I want a written order. Where is that? And what is the motion? What's the basis? Give me some specifics here. And the judge just mentioned, if we have a joint order, something combined where the government the prosecutor here is okay with that, and you're okay with that, it's a stipulated order, meaning we're not going to fight over some of this stuff. I'll sign it. I'll review it and sign it. And so that's the other way to do it, right? There are some attorneys who are, they kind of try to, hold a little bit more of their hand off the books in secret, and they like to address stuff orally. There are other lawyers who come, very prepared. They have their motions in order. They have a bunch of stuff filed before the proceedings take place. And so I think we're starting to see what side of the aisle John Pierce is on. And I've got my opinions on that. I think for a case this high profile, maybe a little bit more proactivity, maybe a little bit more, filing these things immediately, the habeas motions prepared immediately. You've got people from all over the country who are willing to, to jump in and help on this thing. I think there's a lot of resources. And if you watch the full hearing, John Pierce asked for another 30 days, which is not an unreasonable amount of time, but Kyle's been in custody for months now, or will be months by the time that happens. And to me, it just feels a little bit slow. I think that, this is something that could be done more quickly, and the judge also agrees with that. So John Pierce asked for 30 days. The judge gave him 14 days. The next court date hearing on that is going to be on October 9th. and we'll see what happens. Now, Kyle Rittenhouse, we found this while we were looking into it. He's got support from all over the country, all over the world, in fact. So this came from the Bulgarian soccer fans. They're holding a banner that says Kyle Rittenhouse did nothing wrong. And so this case has captured attention of not only myself and many of you who are watching and the rest of the country, but the rest of the world. And, people are pretty invested in this case, which is a good thing because I think it is an important case and we want to make sure that it is dealt with properly. Kyle's next court date, as I mentioned previously, is going to be on October 9th at 10 a.m. We already calendared that on our court docket, our high profile cases docket. So we'll be following that along for the foreseeable future. So if you're not already a subscriber to our channel, hit the subscribe button, and we want to have you here as we continue to follow this story. We follow a lot of different cases, a lot of different stories as they progress. So many news outlets and many, journalists and other YouTubers, they'll cover it when it's hot, but they'll forget about it. But that's where the power is. We want to know what happens with these cases years down the road once everybody else has moved on. So that's why we're putting them in a calendar, documenting everything, and we're going to continue to follow it along right here on this channel. We want to have you a part of that. So let's change gears a little bit. All right, yesterday we spent a lot of time talking about Breonna Taylor. Actually, this whole week we spent a lot of time on it. Wednesday, we learned that Breonna Taylor's, all three of the cops who were involved in that ordeal, none of them were charged for killing her. One was charged with wanton recklessly firing a weapon, endangering the neighbors, but nobody was nailed for Breonna Taylor's death. Even though I've made some pretty good arguments, I think, on this channel about why what we saw from Daniel Cameron, the Attorney General, who came out on Wednesday and did the press release and announced what was going on with the case. I had some issues with that. To me, it felt like a lot of the evidence was sort of cherry-picked. He was pulling evidence and material that looked good for him, and he was talking about one bullet. One bullet left Miles Cosgrove's gun and went into Breonna, but what happened with those 6 other bullets? Where'd those come from? Did anybody ask those questions? We also talked yesterday about this concept of self-defense and justification, and when one officer is doing something in self-defense towards another person who is the aggressor. So in this case, if one of the officers who was in Breonna Taylor's residence at that time is shooting back towards her boyfriend, Kenneth Walker, and hits Breonna Taylor, does the self-defense doctrine protect them? Does that envelope actually secure them against any criminal liability? And I read the statutes with you yesterday here on this channel, and I didn't see anything. I didn't see that the self-defense, the justification doctrine, everything that the Attorney General Cameron was actually talking about, didn't see that it fit the facts of this case. Lo and behold, that's the beauty of Twitter. I was scrolling around last night and I saw another article from another individual who happens to be a law professor, I believe over at Rutgers, and he put this big thread of 6 different tweets, also in concurrence, agrees that the Attorney General got the law a little bit wrong. Now, I didn't know this about the Attorney General at the time, but apparently when he was running for office, he is somebody that doesn't have a lot of criminal law experience. So you don't necessarily have to, right? You can be elected to be the Attorney General or appointed to be the Attorney General, and you don't actually have to have any criminal law experience, right? A lot of the judges don't have any criminal law experience. Heck, in Arizona, you can be a judge in one of our courts and not even have graduated from law school or passed the bar examination. In other words, you do not even need to be a licensed lawyer. You just got to run for office and you can send people to jail in the state of Arizona. So my point being that there's a lot of people in positions of power who really don't know how this stuff works, but they put on a good show. And I think Daniel Cameron did a good job of that. Very articulate guy. I think that, I think he's got a very bright future in politics. He did an excellent job from his perspective on managing that, managing the emotion, managing the press, doing a persuasive job, I think, of putting forward his position in a way that he could do so. He did an excellent job of it. I disagree with it, but he still did a good job, and he's got a role to play, and he's got other things to consider other than the law, like politics and his career and moving up and all that stuff. Not saying it's justified, but I do think that he was leaving out some important parts. And that's why so good to hear from this gentleman, Adil Haki, I think, probably Hake, Adil Hake. He is a law professor from Rutgers. I don't remember right now. I'm having a brain blank. But he says the Attorney General says that according to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. So this is what Daniel Cameron said. he says this justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. All right, so a couple terms of art he's using here. He's using justification as a concept, which is closely related to self-defense, but he's saying the use of force was justified by the officers, which means they cannot be charged with crimes because the police officers can invoke this concept of justification, self-defense. They cannot be charged with crimes. Well, he says that's not actually accurate. He goes on, he talks about the Kentucky Penal Code. He says under 501 or 503-120, self-defense is actually unavailable as a justification in prosecution for an offense involving wantonness or recklessness towards innocent persons. So if Miles Cosgrove or John Mattingly, if they were acting recklessly towards innocent persons, then they don't get to use the self-defense doctrine. And he points to the actual statute here. He says when the defendant is justified under KRS in using force upon or toward the person of another, but he wantonly or recklessly injures or creates a risk of injury to the innocent person. So that would be Breonna Taylor, right? If they're using force towards the person and he wantonly or recklessly injures or creates a risk of injury to innocent persons, the justification that was originally afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness towards innocent persons. All right. He goes on. This is a long thread. He goes on and he says under point 3, he says, even if Mattingly and Cosgrove were justified in defending themselves against Walker, they may have wantonly or recklessly injured or risked injury to Taylor. So self-defense does not preclude charging them accordingly. So he's saying that, sure, because Kenneth Walker fired towards the cops were justified in firing back towards Kenneth Walker, but not towards Breonna Taylor. And if they were acting wantonly or recklessly, so if these cops were just spraying bullets all over the place, and we know that they were, we saw photographs of it, we covered it here on this channel months and months ago, we heard evidence from Daniel Cameron, something like 40 shots I think were fired, tons of bullets just firing all over the place. We know Breonna Taylor was hit 6 times, so if Brett Hankinson fired 10 and the other officers fired between 15 of those or whatever, let's say we got 30 bullets, 6 of those hit Breonna, what happened to the other 24 bullets? 24 plus 6, that's 30. That's rough math. Okay, I've really botched the math on this program before, so I think I got that right, but correct me if I'm wrong. But the point is, where are those other bullets? Where are the 24 bullets? What the heck happened? Were these cops just firing like all over the place? If they were acting wantonly and recklessly, then they're not allowed to invoke justification. They're not allowed to invoke self-defense because they ended up killing a third party who was not the original aggressor. He says, under Kentucky law, a person who uses force as permitted by its self-defense rules is immune from criminal prosecution. So he goes through here. He says, a person who uses force as permitted and is justified in using such force is immune from criminal prosecution and civil action unless the person, okay, and then he goes on. He says, however, self-defense rules do not permit wantonly or recklessly injuring or risking to innocent persons, no injury to innocent persons. The immunity provision does not bar prosecution in such cases. If it did, it would deprive this section of the law any legal effect. So in other words, if you interpret the law according to the Attorney General's interpretation, he came out, and this is where they make their money, right? This is where lawyers are effective, is we're both looking at the same language and we're coming to different conclusions. In Daniel Cameron's case, he came out, he read his version, his recitation of the facts, and he put forward what he thought was a reasonable interpretation of the law. This gentleman is putting forth a different interpretation, one which I happen to agree with. And he's saying that the self-defense doctrine doesn't extend over to them because they were acting wantonly and recklessly, and they ended up killing Breonna Taylor in that capacity. And so he goes back and he says, listen, if the AG believes that both these guys did not wantonly or recklessly injure or risk injury to Taylor, then he should explain why not. Why not? His legal rationale is incorrect. So the alternative here would be to actually charge these people with crimes or to present the evidence that they don't get to invoke self-defense. So what happened in that grand jury? Did Daniel Cameron and his prosecutors, did they go explain any of this to them? I'm going to guess not. I'm going to guess that they weren't as crystal clear on some of these issues as they should have been. So the jurors who were sitting there interpreted it in one way, and they made a decision, and they came to a charging conclusion or lack thereof on that basis. And there were some other quotes from another article that I read, and somebody reminded me of a quote that I forgot, that prosecutors could indict a ham sandwich if they wanted to. You've heard that around probably in other legal shows and stuff. That guy couldn't indict a ham sandwich for a bad prosecutor, right? Really bad, he couldn't do it. Or prosecutors could indict a ham sandwich. I could get indicted for anything, is what people say on the movies and the TV shows and stuff like that. So the fact that a prosecutor didn't indict these two cops, or the third cop, for more serious charges, or for any of those three cops for anything related to Breonna Taylor's death, and he said, he wants to stand up there and say, well, just present the facts. That's all I do. Whoa. And then, try to hide behind that and say, we did everything we could. It was the jurors who came to their own independent conclusion. To me, that just seems a little bit off, but you can, of course, come to your own opinion on all of that. All right, so that's enough of Breonna Taylor. We have a new case, actually, that I just saw yesterday. This involves masks. So we're going to be talking about Alecia Kitts. Alecia Kitts was a woman who was at a sporting event, and she wasn't wearing a mask, which, as we've talked about on this show, that is a cardinal sin. That is a maximum level offense. If we're talking about different levels of felonies, I think a lot of people would like to see masks be like a class 1 felony, class A, like a murder charge, because that's how they respond to it. And that's what we see in this case as well. So this is a story that comes from Ohio, and it's from Alecia Kitts. So this is her. This is Officer Logan City Police Officer Chris Smith. We can see a little bit of size difference here. There's a little bit. I mean, I think Alecia, I might put her, at a $110. That other fellow, Chris Smith, 300 maybe. Maybe a little more than that, maybe 320, maybe. I don't know. But a little bit of a size difference, right? We've got an imbalance of power here. And what happened was Alecia Kitts was at this sporting event. She wasn't wearing a mask. There's some debate about whether she was asked to leave or in, kind of repeat violations of the law. Regardless of what happens, this officer came up. He gets into it with her. Now, as we're watching this, couple things I want to just point out, right? She has already, we know, been charged with 2 crimes here. One is criminal trespassing, and one is resisting arrest. So 2 charges for this incident right here. And the video footage is going to pick up right at the beginning of this whole ordeal. And we're going to see this officer, who I think is even a school resource officer. I think he may have been a retired officer with Logan City Police, or he's acting in a school resource officer capacity. There's different ways they do that, so I'm not sure what his official capacity is. But he's got a gun, he's got a badge, and he looks like an officer, and he's arresting a person. So I'm presuming he's got that capacity. But he's been charged, or she has been charged as a result of him being there. Now we're going to watch this video. He actually tases her in the middle of this ordeal. And I want you to watch closely, because I'm not going to spend a lot of time on the video, but I want you to watch because there's an allegation that the taser actually goes through Alecia and then shocks one of the kids on the bench. So, this officer's conduct is not only impacting Alecia, it's impacting kids and other people who are there. And also take a look at who's wearing masks and who's not wearing masks, right? We've got this Logan City police officer, Chris Smith, who is arresting somebody for essentially violating a mask order. The police come out and they're going to backtrack on this thing pretty hard and say, no, it had nothing to do with the masks, because he's pretty much in violation of the mask order right there. So they can't say we arrested her for masks, because he's not wearing a mask. And another lady who runs up is also not wearing a mask. So these officers have to come up with some other nonsense as to why they had to arrest her. And there may be more information coming out. I don't know. But, this is a situation where she's being charged with criminal trespassing, meaning she's already been asked to leave, presumably, and resisting arrest. But the basis for the arrest was presumably not wearing a mask. That's what triggered this cop to come over and start this whole ordeal. And then that's what led to the criminal trespass. So this all happened very quickly. And so let's break this down. I want to spend another minute on this. If the cop walks up to her and doesn't have a reason for communicating with her. So if he's not approaching her because of the mask ordeal, he needs to have some sort of reasonable, articulable suspicion as to what law she's breaking. Right? You just can't come up to somebody and say, "Hey, I want to see your papers. What are you doing here? I'm gonna arrest you." You have to articulate a reason for that arrest. And so in this case, we have to presume it's the mask, right? She's not trespassing if she's just sitting there watching a football game. So he can't come up to her and say, "You're just trespassing. Get out of here," unless he had already previously asked her to leave. So if we speculate and say 10 minutes before this video, this cop had already asked her to leave and she didn't leave, that would be a criminal trespassing charge. But if he came right up to her and said, "Hey, put your mask on or leave," and she said, "No, I'm not putting a mask on or leaving," then at that point he can say, "All right, she's disobeying a lawful order and she's not leaving even though I asked her to leave, so therefore that's criminal trespass." Then that connects the dot to the next stage in the investigation. It's like connecting the links in a chain. He sees no mask, he comes up, questions her, says leave, she doesn't leave, connects the chain, says, "Okay, you're under arrest." She resists arrest, connects the chain, says, "All right, now you're resisting arrest." That's the sequence of events that leads to 2 crimes, but they all started with the mask order. So if there's no mask problem, because this cop's hardly wearing a mask and one of the other people are not wearing a mask, it all started with the mask thing and then it sort of escalated. He pulls out a taser, tases her in the back. The whole thing just gets, out of control. It's ridiculous. But that's what we're doing right now. We've got people burning down buildings and running over people in the streets and beating officers, shooting officers, killing innocent people, killing business owners. It's insanity. But this lady's got to get thrown out of a baseball game because she's not wearing a mask. Let's take a look at the video because this is a good one and it's a little bit long. So I think it's about 3 minutes. Let's take a look. All right, so there is the initial contact. It's hard to hear some of this. Actually, why is the audio not playing? I'm not sure. So I think we're going to be watching it without audio, but you can see here they're screaming at each other. Now, it actually may be better without audio. So he's flailing around, trying to throw her handcuffs on. This woman's getting, knocked around. This guy's, 2 or 3 times her size. She's screaming at him, "What the F you doing? What are you doing? What are you doing?" Screaming. This kid is freaked out. This guy's just, hanging out, watching the show. And we're going to see this, this continues to struggle. And there's another lady who runs around at some point. She's not wearing a mask. This guy's wearing a mask. And they're all just shouting. I mean, there's really nothing that you're going to glean from, the F-bombs and things that are being dropped. This is just, ongoing. Now, she's putting up a good fight. She's holding on to her wrist. And, she's certainly resisting arrest at this point. Like, there's no question about that. But she is obviously upset and doesn't understand what's going on. This kid's taking pictures. So he knows how to handle the phone and he knows how to handle police officer encounters. Very smart young man. Record, pick up the phone and start recording. It's good advice. So this is still going on right now. Now she's refusing to put her hand behind the back. This person's not getting out of the way. And you're going to see he actually just reaches around and he pulls his taser out and he just jams it right in her back. And she tases, she gets tased, she screams and, she's looking around. What the heck is going on? People around are also yelling. So we'll go ahead and we'll update the link with the full video. I apologize that there's no audio. Again, you're really not missing much. Now see that taser in his right hand? There it goes. Right in her back. Boom. And now she flips. Now this guy also realizes, wait a minute, what just happened? Everybody stands up. She just got tased. She freaks out. She just got tased for not wearing a mask. And now she's being compliant because of that. So, he grabs the gun. Now she gets put in handcuffs or the taser gun. And then his mask is now off. So now he is now officially also in violation of the mask order and also breaking the law. So hopefully he's going to follow her out and leave with her for breaking his own rules. So he's just going to, kind of manhandle, drag her out of the place. And that's kind of about all she wrote, right? That is what we're doing these days. Some guy yells at the officer right now, says, "Hey, what about your mask?" And then he pulls it up and waves, right? He pulls his mask up. Cheerleaders aren't wearing the masks. Everybody in this whole scene was social distancing. I mean, there's no huge crowds. Crowds are certainly smaller than any of the protests that we've seen, any of these, public demonstrations, the crowd. Look at this. So I mean, just look how far away. Whoop, there it is. Look how far away everybody is from each other, and everybody's just kind of blown away. So she gets walked out, and the big question then was she going to get charged? Was this just a situation where she was, just escorted out, but not actually charged with a crime? What's going to happen here? And, there's people on both sides of the mask debate. That's not what we're talking about. We're talking about charging somebody with crimes for this type of violation. And the Logan Police Department are certainly going to do that. So a big part of me was thinking, well, maybe they're not going to charge her, right? Maybe they're going to ask her to leave, and they're not going to actually move forward with this thing. And there'll be some disciplinary, stuff going on or whatever. Not the case. The Logan Police Department is going to, in fact, charge her. So they confirmed that she faces 2 criminal charges from the incident: resisting arrest, a 2nd-degree misdemeanor, and criminal trespassing, a 4th-degree misdemeanor. The charges will be filed in Hocking County Municipal Court, as Captain Ryan Gabriel said, on Thursday. Officer Smith has been an employee since 2000, started as a school resource officer shortly thereafter. It's important to note the female was not arrested for failing to wear a mask, which we just talked about. Of course she wasn't, because other people there weren't wearing a mask. So they needed to find another basis for the actual charge. So they actually decided to go with, she was asked to leave the premises for continually violating school policy. Once she refused to leave the premises, she was advised she was under arrest for criminal trespassing. She resisted arrest, which led to the use of force. Unfortunate incident for everyone involved. And this story comes over from the Marietta Times. And, that's the officer's perspective on this thing, right? That's the police department. They're always going to justify their officers for their actions. It's just part of the deal. You wouldn't expect anything less, right? You would expect your company to stand up for you. So you're going to expect the police to stand up for their officers. Now, the story from the other people who were there is just a little bit different. So I want to talk to you about that. This different version of the events comes from Jack Windsor over at the OhioStar.com. This was published on September 23rd, and he describes a different situation. He says, according to Tiffany Kennedy, the woman who shot the video above, so the lady who was actually recording the video we just watched, said that Kitts had not been warned. She had not been warned for not wearing a mask prior to the officer approaching her. She says that Kennedy also said that Kitts had asthma, and that's why she was not wearing a mask. There's no reason to tase someone and arrest them for not wearing a mask, she said. She also pointed out that the female officer who's shown running towards the Logan officer and Kitts at the end of the video was also not wearing a mask. So another female officer not wearing a mask, pulling one out of her pocket as she was in pursuit. So, the cops themselves were not wearing a mask. Alicia's mom said that the officer, when the officer tased her, the current went through the bleachers and zapped the kid sitting there too. Kid appears to be socially distanced from others in the crowd and sitting with her family. There were only 25 or 30 fans from our side of town at the game. So that's Alecia Kitts. Now we're going to follow this story along as well. I want to see where these charges go and what the prosecutor's office is going to decide to do with them. And, this is something, I know times are heated. I know people are heated, but does somebody deserve criminal charges for this? Does somebody deserve to be tased for this? When they're socially distancing, when they are, sitting next to their family, presumably, when they're not in danger, this ordeal is going to cause... If the purpose of the face mask order is to have less contact with other people, this just created contact between all of those people in that area and that officer and everybody else who's going to be around her as she's going to jail and as she spends time in custody and so on and so forth. So I know the laws exist. I get it. And I know that many people just say, well, that's the law. They shouldn't have broken the law. And, that's their perspective on how to deal with society. Is just, well, that's what the law says. And there is a lot more to that, in my opinion. Anybody who is so black and white, in my mind, give me a break. You've never broken the law before. You've never done something illegal before. We all have, whether you want to admit it or not. The purpose is to let's maybe treat people who go through our criminal justice system with some humanity, with some compassion, with some conversation, not with a 320-pound guy manhandling a 110-pound woman and then tasing her in the back and dragging her out in front of her family for not wearing a mask. Just saying. I know the law. I know what the law says. Is that an appropriate response? What do you think? let's take a look at some of the comments. What do you think about that story? Let's jump into some comments, and then we're going to wrap up the show. I got some pretty good, I think some pretty good gossip on the Supreme Court stuff. Now that's going to be happening tomorrow, but let's take a look at the comments here today. What do you think about Alecia Kitts? Think that was justified? Going to open this up and we'll chime in, see what everybody has to say about this before tomorrow we wrap up. All right. The government has to obey the law, somebody said. I agree with that. I wish that they would. She was trespassing once she refused to leave or put on the mask. I understand that. I definitely understand that. Weight card, that's not okay. The mask is a control device. Somebody says, no idea, Rob, no idea. What is the law that the government has to obey? Our enumerated rights, both privileges and immunity. Michael Weinstein says, are you in Phoenix? Yeah, we are. We're actually in Scottsdale. So we're at Scottsdale Road and Chaparral, right in Midtown Scottsdale. Beautiful place, beautiful new office. It's awesome. It was not a law to wear a mask, says Rodney Nash. Kenneth Reeder says, no, I do not think that was justified. RTDMNA says, no one deserves this. It has been proven that these masks do not work. This whole social distance is ridiculous. And you know, I'm not an anti-masker. I wear a mask. I put it on. I follow it. But what is the deal with the masks, right? I mean, do these things really stop the spread or not? I don't know, you know, and I don't want to be a conspiracy theory person, but I just haven't seen a strong documented story that this reduces the spread. Happy to wear it because the risk factor is so low to me, right? Putting a cloth over my face is not that huge of a deal. I understand the impetus of control. I understand it, but I just don't know. I'm still kind of up in the air. I'll wear it. I got no problem wearing it, but I just don't know yet. I'm still up in the air on that. Yeah. Somebody says they don't even work. This is about escalation. I touch my face 100 times more with a mask on. So do I. I do it too, right? So I have to go work out. I got to wear this thing at the gym, and I'm constantly adjusting it. I mean, I'm constantly doing it. I'm using my hands and constantly using it. And I touch my face a lot anyways, but I think it would be better without that. And unacceptable. Somebody says unacceptable, and I am pro-blue. It's not a law unless it passes Capitol Hill, according to the bill. Well, after months of masks and sanitizing every surface and no germs, what will happen when the flu comes around? Will you wear it for 10 years? I do not expect to be wearing that for 10 years. No question about it. Very sloppy. That cop could have handled it better. Besides, this is all about power. CDC numbers justify it. I only wear a mask if a property owner wants me to on their property. Wear a mask if you want to, or not if you don't want to. Free will. Yeah, I mean, that's kind of my position on it. I'll wear it. I don't have, I'm not going to blow a gasket over the mask thing. But we do have laws in Arizona that require it, and so I am complying. Somebody else says, what should the cop have done instead? It's a great question. What should that cop have done? Should he have tased her? Should he have, I don't know. What could he have done? If he would have addressed the situation a little bit differently, I mean, from what we saw in that video, he just went right after her. He comes up, boom, the whole thing starts. So I don't know what was going on before that. I don't know if there was a long conversation. I don't know if he said, listen, ma'am, I'm going to have to ask you to leave and have a long conversation with you, or, impose some other requirements, or call some other officers around, or, there's a lot of ways you can have a conversation about that. But to me, it seemed like it escalated very, 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 very quickly. Should have had a temperature checker with him to see if she was a problem. Yeah, she's not. Yeah, hey, yeah, it's a great point, right? Let me check your temperature. Oh, you're not sick? You don't have a fever? Great. Yeah, all right, you're good to go. All right, so let's take a look. Let's switch over. Let's go back over to the Supreme Court gossip, because there is some stuff to talk about here. And this is going to be taking place tomorrow. My understanding is that the president announced that it's going to be taking place tomorrow at 5 p.m. Eastern time, which means we'll have a new nominee by the end of the day tomorrow. Now, there's some indication that we know who it's going to be, and we're going to find out. But Trump today announced that he is expected to nominate Barrett, Amy Coney Barrett, to replace late Justice Ruth Bader Ginsburg. This is according to CBS News. They confirmed with multiple sources involved in or familiar with the selection process, according to their article. They say all sources cautioned that until announced by the president, there is always the possibility that Trump makes a last-minute change, but the expectation is that Barrett is the choice. This is according to CBS. He is scheduled to make the announcement tomorrow afternoon. White House declined to comment. So CBS is reporting that it's going to be Amy Coney Barrett. We've already sort of been speculating that. If you've been following this channel this week, we've been doing a live stream every day at 4 p.m. It's been a lot of fun. I'm going to keep doing it, at least for the foreseeable future, until we know who the nominee is and whether they get seated or the election happens. There's just so much to talk about. I just can't leave it to one day. So we've been talking about it for a long time, and it has been looking like the trend this entire week has been that it is going to be Amy Coney Barrett. And now the markets responded accordingly. So we've been following the markets. Amy Coney Barrett is now really, really basically at the very top, right? When this reaches 100% or 100 cents on the dollar, that means that she is the nominee. So nobody is putting any money on anybody else. Yesterday, there were no men on this list. They were all women because we know that Trump is going to pick a woman. But now we see some funny bets like Merrick Garland, right? What is the likelihood that Donald Trump is going to nominate Merrick Garland, who was Obama's choice for the Supreme Court? About zero. So everything else on that list is good. And I do think that it's probably very likely that it is going to be Amy Coney Barrett. Probably don't even need to speculate anymore. Back over to predict it. We'll see that the charts are also showing the same trend. So we've got Amy Coney Barrett. She was up even a little bit more yesterday and then back down. Going to, very likely going to be going up and up and up tomorrow, especially when she receives the nomination. So that means that we've covered this a lot here on this channel. It's been about 52 to 48, I think, is what the Senate split is still today. That means that as long as all 52 of those senators are okay with that pick, it's probably going to be Amy Coney Barrett on the Supreme Court very soon before the election. They're going to nominate her. They're going to confirm her. They're going to cram her through. Probably going to be a short, contentious hearing like it was with Kavanaugh, but we're going to have to wonder, what are the Democrats going to do, right? What are they going to do about this nomination process? How are they going to handle it? We've seen a lot of ideas floating around. A lot of people are kind of up in the air about this stuff, but who is going to lead the Democrats through this? Are they going to, have somebody who's going to actually put up a fight? Are they going to roll over on this thing? Just because now we have to think about the politics. What are they going to do? Well, we know now that some senators are very concerned about who is in charge of the Democratic caucus or the Democratic portion of the Senate Judiciary Committee. We've talked about previously who is on the Senate Judiciary Committee. The Senate Judiciary Committee is responsible for doing that interview, for holding those nomination confirmation hearings. You remember this with Brett Kavanaugh when he was nominated, when he was getting, accused of all sorts of heinous stuff from 25, 30 years ago. We saw Kamala Harris. We saw all these people really, really beating him up and asking him some pretty, I thought, very grotesque questions for a man who's been basically perfect his whole life. He went under a lot of abuse for that. I thought it was pretty gross. I stand by it. It's not because he's a Republican or a conservative. I just think it's very poor decorum, and the evidence didn't meet the threshold that I thought warranted any real discussion about it. I'm a criminal defense attorney. He was being accused of crimes. I didn't see any evidence that had any merit at all. It was a political spectacle. So we're going to have to ask ourselves, are we going to get that again? I think a lot of America, most Americans, regardless of what political side you were on, saw a disgusting spectacle of political nonsense. So the question is, are they going to do that again? Is this going to be a repeat of last time? This is the Senate Judiciary Committee's team. This is who they are for the Democrats. This is who they're working with. And Dianne Feinstein is right at the top. Now, there are concerns about her, and I'm going to share that story with you. But first, this is the Republican side, right? So we've got some actually firebrands on this list. We've got, Lindsey Graham's pretty articulate guy, but really Mike Lee and Ted Cruz, both those guys are very, they're very aggressive. Ted Cruz is a lawyer. I think Mike Lee is too. Both good debaters. I think Ted Cruz, won or was like champion of, the debate universe or something like that. So these individuals are going to be sort of opposing one another during these confirmation hearings. And some of the Democrats are concerned that Senator Feinstein just can't handle it. She's too old, in other words. So there's some gossip around this nomination process saying that they worry that Senator Feinstein can't handle the Supreme Court battle. Feinstein sometimes gets confused by reporters' questions or will offer different answers. Her appearance is frail. She's got, this story comes from Politico.com. She's got a genteel demeanor, which seems like it belongs to a bygone Senate era, and so on. A Democratic senator, speaking on condition of anonymity, said that a group of Feinstein's colleagues want Dick Durbin or Sheldon Whitehouse to serve as the top Democrat. And, they're concerned about potential missteps by Feinstein that it could cost some votes in the Senate. So, it's going to be very curious to see who is taking the lead for the Democratic Party. I'm going to be interested to see what Kamala Harris does. Is she going to come back here and take the lead on this thing? She's been very absent as far as I've been reading from the campaign trail. So we don't know whether or not she's going to, take an active role or really kind of try to stay quiet and let the rest of the Judiciary Committee from the senators, from the Democratic senators, fill in for her. We just don't know how that's going to work. Now, it's going to be, I think it's going to be probably a contentious fight because that's just what these senators do. But they're also trying other things. So if they're not successful with the confirmation hearings, what are they going to do otherwise? Are they going to try anything else? I want to introduce you to 3 Democratic House of Representative people who are upset about this nomination and who want to make sure that this individual, whoever Trump nominates tomorrow, probably Amy Coney Barrett, is, not on the bench forever. They don't want this person to be on the court for the rest of their lives. If you remember back from your constitutional law class or civics or social studies, when you're appointed to the Supreme Court, you're appointed for life. You get to stay there forever until you die. That's why it's like this watching this slow motion, just death experience happen with all of these old judges. We watch Ginsburg just kind of slowly degrade in front of our very eyes. It happens all the time. They hang on till the very end, then they die, and we get to appoint somebody else. Now, what happens is that power comes from the United States Constitution. And we have these 3 representatives who, apparently have not read the U.S. Constitution because they are trying to introduce a bill that would negate that lifetime tenure appointment by the Supreme Court. So these 3 individuals, of course, they are all Democrats because they're upset about what's going on. We have Rohit Khanna from California. We have Joe Kennedy III, the chapstick guy from Massachusetts, and we've got Don Bayer from Virginia. These 3 guys, I'm not sure that they're constitutional scholars. They seem to think they are, but let's just inform them once again that if they have not read Article 3 of the U.S. Constitution, that it may be a good time to do so. This is what it looks like. It says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts, and as the Congress may from time to time ordain and establish the judges, both of the Supreme and the inferior courts shall hold their offices during good behavior and shall, at stated time, receive for their services compensation, which shall not be diminished during their continuance in office. That's language directly from the U.S. Constitution. It says that there is no term limit there. It says that there's no mandatory retirement. It doesn't say that they can only stay on for 5 years, 10 years, 18 years. None of that language is in there. And it addresses their time in office. They get to hold their office during good behavior. That's the only requirement. You can impeach them. You can remove them from office if they're breaking the law or violating the Constitution or for other reasons. But as long as they're on good behavior, that is their seat for life. You can have an opinion on that one way or the other. You can say that's kind of a stupid idea. I think there's some really good arguments for that because of some of what we see in terms of the politicking and those things. But in order to change this is part of the Constitution. The Constitution is very difficult to change. It requires a constitutional amendment. We don't have a lot of those. It requires huge supermajorities. It requires approval by the states, ratification by the states. But these 3 representatives that I just showed you, they want to introduce a new bill, which would be a congressional bill. My understanding is this is not intended to be a constitutional amendment that would actually limit the U.S. Supreme Court justice terms to 18 years. So they want to say, instead of that life tenure that you were entitled to under the U.S. Constitution, we're only going to give it 18 years. This was from a Reuters article, and they said that they're going to do 2 things. They're going to try to limit lifetime appointments to 18 years, and they're also going to only allow the president to nominate 2 justices per 4-year term. Trump is on his 3rd pick. They don't like that. They only want 2 picks per term. So if somebody else goes away, who gets to pick that person? I don't know. I don't know what these knuckleheads are thinking. I don't even know if they've read the Constitution, but none of this stuff is going to fly. You got to amend the Constitution. But they're trying everything they can. They're really upset about this thing. They are literally trying everything. This next story, they are even trying to enlist the help of Satan. Yes, that's right, folks. I know. I saw this story, another story from the Huffington Post. It says, the death of Justice Ruth Bader Ginsburg pushed me to join the Satanic Temple. Oh, okay. This is from a 40-something-year-old attorney and mother who lives in a quiet neighborhood with a yard and a garage full of scooters and soccer balls. I'm not the type of person who would normally consider becoming a Satanist, but these are not normal times. So this speaker, Jamie Smith, which I'm assuming is a pseudonym, is a guest writer for Huffington Post. She is joining a satanic temple. Well, what does that mean? What is she talking about? Why would you need to join a satanic temple when a simple Supreme Court justice passes away? Well, she says that the Satanic Temple has a code their members believe in. It deeply guides their lives. They have 7 fundamental tenets, one of which is we should always strive to act with compassion and empathy towards all creatures, as long as we do it in accordance with reason. Apparently, that is a satanic temple. Another one is that one's body is inviolable, which means that they are subject to one's own will alone. So this is where the abortion topic comes into play. So it sounds like to me this woman is actually trying to equate the two, which is not an interesting look for somebody who is probably in favor of that issue. They said they have an unwritten code. They use it to guide their lives, and the Supreme Court is unwilling to provide adequate protection for their bodies, which is why they need to join a group of Satanists who believe that their bodies should not be violated. She says, we need a creative, resolute thinkers who are willing to stand up for what they believe in and take concrete action to do so. And the Satanic Temple is full of those kinds of people. I'm proud to now count myself among their ranks. So things are getting wild, folks. We're now talking about Satanism and the Supreme Court. Didn't think that would be happening in 2020, but we have a lot of things that I didn't think would be happening in 2020. Does anybody here follow Scott Adams? I'm a huge Scott Adams fan, and when I saw this story, I couldn't help but think about something he talks about on his morning Periscopes. He doesn't believe in Satanism. He's not a religious guy, but he's been seeing these satanic references throughout this election. So he posted on his Twitter, he said, if you divide, I think it's 2020, or I think if you divide 666 by 2020, then you get 303 or something like that, which is Joe Biden campaign. It's his text message number or something like that. So he keeps drawing these weird conclusions between what the Democratic Party is doing in Satanism, and this story just popped up. Now, I am not, I'm trying not to be too political here. I don't think the Democrats are Satan, but it is a funny coincidence and a funny story. So, all right, my friends, that is it for the show today. Let's go back to the chat. I'm pro-right and anti-wrong. Gary Martin, not surprised that a liberal wants to be a Satanist. They have for years. Let's see. I'll check your Constitution. Satanic Court of the U.S., SCOTUS. Yes, Satan does support abortion. I'm not very religious, but I'm also against it. It's not right versus left here. This is right versus wrong. Hello from Brazil. Hey, Leandro, how are you? Scott is amusing. Yeah, there's a lot of stuff going on out there. How do you feel about BLM Rob? That's a great question and a huge, huge topic. And I've explained it on this channel for a long time. I don't really understand it. I really don't understand what their movement is about. And I've done my research on this thing. When BLM was first sort of evolving, I was sympathetic with their cause and their movement. I've talked about the George Floyd situation, and this show has been going on since March, and I've been covering this type of stuff for a long time, even before then. We started holding up the mugshots of the bad cops. I started really beating up on the bad officers long before Watching the Watchers started. And so when the George Floyd situation happened, I was very much in alignment with I still am, with wanting to see justice reform, wanting to see bad cops held accountable, wanting to see, more compassionate type of justice in our justice system, and not this war zone mentality and this culture that we see with law enforcement, where every altercation with somebody turns into this, this life or death battle. I don't think it needs to be that way. So when BLM was starting to foment, I was very curious. I wanted to see, what are they going to be standing for? What are their actual aims here? What do they want to see change? Do they want end to qualified immunity? Do they want, more representation in civilian oversight boards? Do they want, what do they want? Do they want mandatory body cams? What is it that's going to help solve this problem? And for the longest time, I could not identify it. I still can't identify it. I don't know what it's going to take for them to be satisfied. I have no idea. And when you don't have a clear leader of a movement, or you don't have a position, or you don't know what it's going to take to have both sides come to the table and reach, to rectify things, then you can't have any productive dialogue. You just can't. And I still, to this day, have not seen what they want, other than they want people to just say Black Lives Matter, which I agree, Black Lives Matter, right? But I don't know what that means. I really don't. I don't understand what they're trying to accomplish. And as this movement has evolved, I think it has become more about a political movement. It's become more like a left versus right argument. BLM has evolved into this sort of almost extension of the Democratic Party, and I don't want to be a part of that. The same thing, if the Republicans were doing the same thing, I don't want to be a part of that. My issue is with law enforcement. It's with prosecutors. It's with politicians. It's with judges. It's with our criminal justice system impacting the liberties of people who are going through it. And that is what I care about. I don't care about the race stuff. I don't care about, the political stuff. I mean, I do care about all of that stuff. Don't get me wrong. But on this channel, this is about the police. This is about prosecutors and judges, and how can we move that system forward? And I have not heard any good ideas from BLM or for anybody who's even sympathetic to BLM. It's just been sort of this movement without a real cause. It's a bunch of angry people who want to see some changes, but they're not real clear on what those changes are. And I've been on their website, and I've seen, their language about ending white supremacy, or, diminishing the patriarchy, or, eliminating white privilege, or systemic white racism. I still don't know what any of that means, or I know what they're implying with it, but so what? So what? Now that we know what you're upset about, so what? What do you want to see happen to move the ball forward on this issue? I don't know what that is. I still don't. Yeah, somebody says, that's the truth. This is from a BLM supporter. BLM is lost, man. It's frustrating. Yeah, it's really frustrating. And I got to say, I've made this point a lot on this channel. It's been really deflating to see. At one point in time, the whole country was unified, right? We all saw what they did to George Floyd, or, people are disagreeing about that, but we saw that video. The whole country saw the video, regardless of whether you want to say it's fentanyl or whatever. We saw it, and we were all disgusted by what we saw. Everybody was. I had police friends, and I follow a lot of the police unions, so I can keep tabs on them. Even they were saying, look, this is not good. We're going to look at things. We're sorry. Sorry. The country was moving in the right direction on criminal justice reform. We were all moving in the right direction. But then a few days later, buildings are getting burnt down and people are getting shot, and there's chaos. And okay, I understand they're upset, but let's blow off some steam and let's get back to focus. Let's focus on justice reform. Let's focus on people. And it just never got on the right track. It still spirals out of control. There's still no message. They're still burning things down. Every time there's a new case, it's more chaos, more disruption, and that hurts the movement. Everybody who was on George Floyd's side now is looking back, and they're saying, those guys are animals. Those guys are monsters. The cops are right. The cops should be, using a heavy hand. How many times have you heard from the conservatives on the right, Ann Coulter and a lot of these people, hey, this is Trump's America. Trump's letting this stuff happen. Trump should go in there with the feds. He should send the National Guard in. He should go crack heads and break skulls and just, and get this stuff in order. And it's like, that is not what we want. We don't want that. That's what we're trying to stop. We don't want law enforcement and troops and militarized justice system. We want a civilian justice system. We want quiet. We want civilian reforms, because we are civilians. We're not in a war zone. We're in America. Why are we letting the other side take the power back on this criminal justice reform movement? I have totally soured on BLM. I've totally soured on the protesters and the rioters. I explained that yesterday. They're all part of the same group of people who are causing more damage to the movement than any good. And it's deflating, because I've made my whole life and career about helping people going through the criminal justice system. And I thought, finally, we're talking about this stuff. Finally, there's a movement in place. And now it's just being squandered because people are angry and they're burning stuff down. It may make them feel good temporarily, but it's not going to change a damn thing, and it's a damn shame. So that's what I've got today, folks. It's that time on a Friday. I want to thank you so much for being here. A quick ask. If you have seen in the description, I'm part of a nonprofit called ericshouse.org. It's to help people who've lost somebody to suicide, addiction, or overdose, or a tragic death. There's a description, a link down there to a fundraising page. If you have any amount of will to help those people who need support, if you could, drop $5, $10, whatever it is, it would mean the world to this organization. A lot of good people. 2020 is causing a lot of people to have problems with alcohol and drugs and other addictions. And a lot of people are unfortunately dying because of these lockdowns and because of the pressure that everybody is under. So ericshouse.org is an awesome organization. If you can donate, help them out, that'd be awesome. If not, no worries. I'll see you back here on the next show. Don't forget to hit that subscribe button. If you like this show, I would really love it if you shared it with somebody because it's a lot of fun to have people here chatting about this. I love seeing, the activity and the communication. It's so exciting. It's a lot of fun. We'll very likely we'll be back here tomorrow to discuss the Supreme Court announcement. I haven't decided if I'm going to live stream or not yet, but if I do, I will schedule it on our page. Everybody have a great and wonderful Friday. Thanks again so much for being here.